Welcome to our little meeting here, and we're ready for your opening statement.
Thank you, Justice Wiggins and members of the Commission. Thank you for this opportunity to speak with you. I've really enjoyed this application process, at least so far. My name is Joe Barron. I'm originally from Audubon, Iowa. I grew up with 8 siblings in a drafty old house that was once the home of Justice Halleck Mance, who served on the Iowa Supreme Court many years ago. I did my homework at a dining room table in a room where he wrote his judicial opinions. Thinking about that now reminds me that the Iowa Supreme Court is not this magnificent building that we're in. It is not a lofty and unreachable authority. It is a group of dedicated and hardworking people who do their best to resolve the disputes properly brought before them and to do so objectively and according to the law. I myself have been in private practice for 22 years. My experience is laid out in my written submissions. I won't bore you with a recitation of that now. I would, however, like to say that I've spent the better part of those 22 years deliberately and enthusiastically developing what began as a general litigation practice into a more specialized practice as an appellate attorney and brief writer. Today, I'm fortunate to say that I have exactly the practice that I've always wanted to have, presenting appeals and writing briefs on a variety of issues. I have handled more than 70 appeals to the Iowa Supreme Court and the Iowa Court of Appeals. I suspect very few attorneys in private practice, if any, have handled more such appeals. I consider myself to be a reflective person, an analytical person. I do not jump to conclusions regarding important legal issues. My nature is to do the research, seriously listen to the opinions of others, reflect on the matter, and then exercise and express my analysis in written form. I am confident my colleagues and members of the bar who are familiar with my work would tell you that I am a conscientious person, even-tempered, and considerate of the opinions of others. At the same time, I am accustomed to a high-volume, deadline-intensive practice, analyzing complex legal issues on a daily basis. I think this experience has prepared me well to serve this state as a justice on the Iowa Supreme Court. Although my practice has encompassed a wide range of cases, it does include a heavy concentration of workers' compensation litigation. And with your indulgence, I would like to make the case for nomination of a person with an extensive workers' compensation background. I would submit that workers' compensation is the fastest growing area of law in Iowa. Currently, over 4,000 petitions are filed with the Iowa Workers' Compensation Commissioner each year, and those are only those cases that are in the litigation phase. Far more workers' compensation cases are litigated in Iowa than civil personal injury cases. I think there are more attorneys practicing in that area than almost any other area. I don't believe that was the case 15 or 20 years ago. At the same time, the size of the awards has grown dramatically. When I began practicing, a work comp award of $50,000 or $75,000 was considered significant. Today we are seeing awards well in excess of $500,000. Workers' compensation has become a highly specialized and increasingly complex area of the law. In 2010, the Iowa Supreme Court issued 133 opinions. 13 of those were in workers' compensation cases. The need for guidance from the Iowa Supreme Court in this area is important and always immediate. I urge you to find a place in your nomination pool for a person with considerable experience in this area. Other than experience, what could be more important in this nomination process than judicial philosophy? Mine is simple, and I would certainly hope it is conventional. The justices of this court and the Iowa Court of Appeals have a sworn duty to decide all legal controversies properly brought before them within their jurisdiction. They have no choice in the matter. Those decisions must be based on the law as the court in good faith determines it to be, without regard for personal bias or popular opinion. I believe our Supreme Court has done a commendable job of doing just that. For an example, we need only look at the 1992 baby Jessica case that resulted in the return of a 19-month-old girl to her birth parents in a gut-wrenching situation. That decision was certainly unpopular with the public. More recently, the court decided the 2006 Hingster case involving a reversal of a murder conviction and a remand for retrial. In 2007, in the James Bentley case, another emotionally charged case, the court decided a videotaped statement of a 10-year-old murder victim had to be excluded from evidence. In each of those cases, the Iowa Supreme Court issued decisions that were publicly unpopular, but the court based its decision on the application of the applicable law. The fact is, reasonable minds can and did disagree with these decisions, but it cannot reasonably be argued that the court bowed to public opinion or altered the outcome for fear of reprisal. We should be proud of this. Without even commenting on whether I personally agree or disagree with the outcome of each of those cases, I am proud the court decides such cases based on a determination of the law without regard for public opinion. During the past year, the Iowa Supreme Court has come under an unprecedented attack that challenged the very notion of an independent judicial review by a separate, equal, and nonpartisan branch of government. The loss of 3 justices and the continued attacks on the court galvanized me to look inward to determine what I could do to serve and defend the judicial system of which I am so proud. Members of the commission, I love my law practice, but as a lawyer sworn to uphold our courts, I simply could not stand by and do nothing. Sometimes one has to leave his or her comfort zone to step up and do what's right. I know 60 is a large number of applicants, more than we have ever had before. I think that's wonderful, because our system of fair and impartial justice in Iowa needs protection now more than ever. If I should be so privileged as to be appointed to the court, I give you my solemn promise to do just that. Thank you. I'd be happy to answer any questions.
Do we have any questions from this side of the table? Mr. Fitzgibbons.
Thank you. Good afternoon, Mr. Barron.
Good afternoon.
Thank you for being here. And as I've stated to a few of the fine people that have come to see us, the fact that we have a great group of people that are making application, I think validates our process, the process that's worked for many, many years. I'd like to know your opinion if you were chosen by our commission and if Governor Branstad chose you as a Supreme Court justice. Is there any particular justice you've observed through your substantial research, your considerable research, or perhaps you've known that you would try to emulate? And of course, for purposes of this question, I should probably eliminate Justice Wiggins. But
I don't think he'd pick me anyway, to tell you the
well,
truth.
I'm not going there. But just, could you help us out philosophically, or just someone that you think was an outstanding jurist in our state?
I have been an admirer of Justice Michael Streit since the ink was wet on my bar admission. I clerked at the Polk County District Court initially. He was there for some of that year working. I met him at that time. I've had a number of occasions over the years to both speak with him and obviously read his decisions, and I've always admired him. He officiated at the wedding of my wife and I. That was very special to us. We picked him because of our great respect and admiration of him, so yes.
Mr. Pace?
Thank you. Thank you, Justice Wiggins. Good afternoon.
Good afternoon.
I wanted to give you my condolences. I see you're an appellate partner at Petticord Wharton, and unfortunately, they never hardly ever lose. So I don't know what you're going to be doing. I got a letter from my good friend Jack Wharton, and he said you're the appellate partner, so you're the go-to person at that firm for the appellate work. But then I'm sure they lose. Somebody must lose there occasionally. They always beat me. But he says you're the lawyer, a lawyer's lawyer. And he says that you have a unique ability to combine your analytical skills with a down-to-earth common sense approach and apply that to the issues in a case. I'd like you to tell us how you do that.
That's very kind of him. I appreciate that. I think what I love is the pure law. I really do. I write briefs. I make no apology for that because I love it. And I love analyzing legal issues. I think the fact that I, most of the time, am writing appellate briefs or any kind of briefs for people who are handling the case initially, meaning it's not my case. I'm not the person who's been in on the case initially. I become involved later, means that I have a different perspective. I wouldn't say necessarily it's the perspective of a judge, but I can be more objective. It's hard when you are the advocate knocking heads with the other side as opposed to someone who can try to take an objective look at a situation. So that's what I love to do. I like law, and in that I mean the purest form of law. I love case law. I love looking at legal issues and analyzing them.
Thank you. Ms. Walker?
Thank you, Mr. Barron. I guess my question, from what I can tell, you've done a lot of work for insurance companies, and I come from a firm that probably has a different perspective. And so I guess what can you do to reassure myself and other people that you would be willing to set aside the insurance company perspective and look at the case from a balanced perspective if you were a justice?
Thank you. I have represented claimants in my career. I have worked with other attorneys in my firm representing plaintiffs in my career. With that said, yes, we are primarily an insurance defense firm. That has been the bulk of my work. My own philosophy is both sides to every case deserve good representation. The system works best when they both have good representation. I will confess that I have been involved in cases where I felt a great deal of sympathy for the person on the other side. But I had a role to play, and my role was as an advocate for my client. It's almost always the case that the claimant or plaintiff, as the case may be, has very good representation on their behalf, and that's the way it should be. As a judge, I would be in that role, and I can assure you I will not be an insurance defense judge. I believe cases should be decided on the merits, on the facts, and on the law, regardless of sympathy.
Mr. Mickelson?
Mr. Barron, what do you think the let's say the single most important need is for the judicial branch right now, as far from an administrative standpoint?
There are two. Right now, at this precise moment in time, there is a public perception of the court that is very disturbing to me and probably everyone in this room and probably most of the bar. I think we are at a crossroads right now. And the public perception of the court system, the Iowa Supreme Court, is not good, and in my humble opinion, sometimes not very well informed. So that is a need that we have right now. I think there's only so much that the Iowa Supreme Court justices can do about that. The bar needs to step up and has started to do that, but it's the bar that's out in every single community in this state. We're only going to have 7 justices. They can only do so much. They have been engaged in activities out in the public, but I'm well aware that they do a tremendous amount of work besides the deciding cases. They administer the entire judicial system. So to me, that's got to be more of a bar function, and frankly, just an activity of the good citizens of Iowa to try to develop a better awareness of what the judicial branch is. Other than that, there are budgetary problems, and I guess that would be my second, probably more long-term. I think public perception right now is a problem. Hopefully, it won't be in the long term. The budget is a problem right now.
Any questions down this way? Mrs. Williams?
Mr. Barron, thank you for your application. During your remarks, you mentioned you wanted to step up and do what's right. What do you think sets you apart from the other 60 candidates or so that we have right now?
I know many of the other applicants, and I believe it is a fine list with just stellar people. I don't know every one of them, but I'm very impressed by the 60 applicants. As far as my own desire to serve the court, I wouldn't want to comment on how it compares to theirs, because I know there are many good people there. I believe that my work experience and skills that I have developed would be a natural progression to the type of work that an Iowa Supreme Court justice does. And also, I make no apologies for my workers' compensation background. I think that is an important attribute that could be of benefit to the court.
Mr. Brody?
Given that there's still more time, I always have plenty of questions to ask. So I was struck by your note in your material that you provided with us, which you said the driving force which drove you to be an appellant lawyer. And then your answer to Mr. Pace, to his question, which then leads me to, how do you handle where you're an objective observer to somebody who is bringing to a trial attorney who is impassioned about their case, where you're just sitting there looking at it and you're going, I don't see anything here, or you erred here, or this is a track you should have taken? How do you work with that person who's bringing you that case? And do you have a couple of good examples of?
So welcome to my life.
Yeah, okay.
That's a weekly, if not a daily occurrence, because that's what lawyers do. We talk about cases, we look at what's happened. There's always a decision on whether to appeal or not, and if so, what issues to raise. And I think that that my colleagues would tell you that I do a good job of just discussing the issue with them, and sometimes we disagree, and that's fine. There's nothing unusual about that or unexpected. I'm not sure I would want to name particular cases, but I have written briefs on cases where if I was the client, I might not have decided to appeal that case. I think every lawyer could say that when the decision is ultimately the client's, as it should be. Sometimes the lawyer is espousing a position they don't is likely to prevail, but their client deserves their day in court. I hope that answers your question.
Thank you.
Mr. Barron, I think you may be a little bit modest there, because you do try cases. Because the second to the last case I lost was, you were on the other side, if I recall.
Well,
And Joe was at the last case I lost before I took the bench. But you do have some courtroom experience, though.
I do have some. I don't claim to be a greatly experienced trial attorney, particularly in front of juries, but yes, I have some.
Good enough that day.
Thank you. Thank you.
Mr. Cook?
Thank you, Justice Wiggins. Sir, we're not only charged with combing through the applicant's professional background in terms of qualifications, but ultimately we have to decide who are these people. And we had, in fact, one applicant say, look at who I am outside the law. And there's a unique connection between that candidate, and I see your materials here. He was president of the skydiving club. I see in your materials you've jumped out of an airplane over 1,000 times. I say this in all seriousness. What does that say about your personality and character?
I don't think it says a lot in terms of my qualifications for the Iowa Supreme Court. I will describe that activity, and I know Steve, lawyer, he's probably done a lot more jumps than I have, frankly. But it is a sport. We do it very safely. We're very conscientious. I love it as a diversion. When you jump out of an airplane, the only law you're thinking about is the law of gravity. And that's a wonderful thing.
Any other questions from the panel? Mr. Barron, we thank you very much, and we wish you the best of luck.